Nervous shock. Test of directness for determination remote of damage was laid down in the case of repolymesh. What defense could be used when an injury is caused to a person due to unforeseen or unexpected event in spite of reasonable care and taken by him? Inevitable action. The maxim exo personals mortris cum persona means personal action die with the party to the cause of action. Match the incorrect entries. C is incorrect. Which one right? Injuria sin Denham, Ashray versus White. Denham sin Injuria. Gloucester case. Negligence. Donlock versus Stevenson. The liability for tort arises on violation of a right in personam, breach of legal duty. 2 and 3 is right. Doctrine of desuetude refer to state of disuse, contrary practice being adopted. In which one of the following case Lord Wilberforce opined that it is necessary to consider their three element inherited in claim of nervous shock. That case of a person who claims should be recognized the proximity of such person to the incident and means adopted by which shock is caused. MC Logan versus O'Brien 1983. Which one of the following statement is incorrect? Nervous shock is nothing but a kind of physical injury, right? Nervous shock must have been due to fear immediately personal injury to oneself. Wrong. Nervous shock is seeing danger to the property is not actionable, right? All of the above is only B is incorrect. 1 and C, A and C is right. In which one of the following case Lord Wilberforce opined that it is necessary to consider three elements inherited in the claim of nervous shock. The class of person who claims should be recognized, first one. The proximity of such person to the incident, second. And the means adopted by the shock is caused. MC Logan versus O'Brien. Which among the following cases related to the rule that caused the death of a person is not a tort? Rookies versus Bernard. In which one of the following cases Justice Kennedy's limitation to claim relating to nervous shock that the shock must have been due to fear of immediate personal injury to oneself was rejected? Answer: Hambook versus Strauch's brother, 1925. Principle: a defendant is liable for all direct consequences of his act or omission, which he could have reasonably foreseen as a natural flowing from his action. Factual situation. A bus driver was driving a bus along with BRT corridor in New Delhi. At a bus stand, he carelessly drove the bus, resulting in hitting of railing and crushing the marshal on duty at the spot. A lady standing at a distance, on hearing about the accident, rushed to the spot and saw the injury covered in blood, hanging pieces on the railing. The sight terrified the lady. As a result, she fainted and had to treated for nervous shock. The lady on recovery filed a suit for compensation against the driver and the owner of the bus. Answer: she will not succeed, as the driver could not have foreseen the illness of lady who came to the site. When the defendant, by his act, created an apprehension in the mind of plaintiff that he is going to commit a battery against the plaintiff, the wrong of assault is completed. Which one of the following statement is true in malice in law and malice in fact? Answer: former is wrongful act done intentionally, while just cause, whereas the latter is wrongful act done unintentionally with evil motive. Next question. Although prima facie and general rule, there must be mind at fault before there can be a crime. It is not an inflexible rule, and to statutes may relate to the subject matter may be so framed as a matter of act is criminal, whether there has been any intention to break the law or otherwise to do wrong or not. This is held in the case of R versus Tolson. The famous case of 6 Carpenter 1610 discussed the concept of dispossession. The maxim actus curiae nemem grabetem means act of court shall prejudice no man. Match: wagon mound case. Test for reasonable foreseeability. Polymus case. Test for directness. Smith Leach versus Brain and Company. Eggshell skull rule. Smith versus Carls Bakerson. Volenti non-fit injuria. A is right. Which one of the following is correct? Answer the using code below. Corporation is vicarious liable for act done by its employee, right? Minor is liable for tort committed by him, wrong. Minor is liable for tort committed by wrong, right? Not wrong. Wife is liable under tort to her husband if she negligently fractures his leg, wrong. Tort committed by any partner in ordinary course of business of firm, all other partners are liable, right. C is wrong, rest is right. Answer is C. A, B and D. The degree of consign needed not reach certain but must be carry high degree of probability. As per the statement answered using code below in the situation in sequential order, the principle of natural justice is applied. Strict liability first number पे, then presumption of innocence second number, then alibi, last is self incrimination. For D C A B is right answer. The maxim injuria non executa injurium means one wrong done to justify another. The term peri passu means equal right to another creditor with that the secured creditor. Manju Bhatia versus New Delhi Municipal Corporation. Liability of builder toward the purchaser of the flat. Delhi Municipal Corporation versus Susila Devi. Liability of owner of tree for an injury caused by its falling. Union of India versus Lalman. Legal duty of railway to assure reasonable safety at a railway level crossing. MS Geriwal versus Deep Chand Sood. Teachers' duty of kids toward children when they are taken out on picnic for fun and swim. In which one of the following case the principle of common employment was evolved for the first time? Answer: Priestcliffe versus Pollard. The traditional test of determining relationship of master and servant is control test. Which one of the following tort is not related to nuisance based on physical discomfort and interference with another health and safety? Injury to property. State of Susrut versus Menon Haji Islam. Municipal law does not apply. Delhi Transportation Corporation versus Kumari Lalita. Suit by minor. Brown versus Lewis. No right to sue as unincorporated association. Campbell versus Pedigoton. Suit against corporation. Ex turpi causa not obscuria. From the immoral cause of an action arises. De minimis non curat lex. Law does not concern itself with trifle. Causa causan. Immediate cause. Die in denim. From day to day. Chronological order. सबसे पहला है अनवर हुसैन वर्सेस ओजय कुमार. फिर नेक्स्ट विनोद कुमार संतालाल गोसालिया वर्सेस गंगाधर नरसिंहदास. देन निजाम इंस्टीट्यूट ऑफ मेडिकल साइंस वर्सेस पारसनाथ एस धन्ना. सोदन सिंह वर्सेस न्यू दिल्ली म्युनिसिपल कॉर्पोरेशन. 3, 1, 4, 2 is the right answer. Sorry. 3, 1, 2, 4 is the right answer. C is the right answer.